Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Hey guys, this is my private Facebook group, which is Foreclosure Help 777, and if you're in foreclosure or you need help or just want to be with other like-minded people, you can join my private group. Just send me a request to join and I will approve you, and we will collaborate and try to help each other. Okay, so today we're going to go over quiet title actions and some things that everybody needs to be aware of. These are just some things that I wrote some notes about to help y'all, and let's talk about them. Elements of a quiet title action. A quiet title action is a lawsuit asking the court to determine who has valid title to property and to remove any adverse claims or clouds on that title. The exact elements vary by state, but generally a plaintiff must plead and prove certain things here. Number one, plaintiff's interest in the property. The plaintiff must allege ownership or another legally recognizable interest in the property. This means that when you file your lawsuit, you have to include a copy of the deed, the warranty deed, that shows you're the owner of the property as an exhibit to your complaint. That's the first thing to do. Example, deed, inheritance, or long-term possession. But I think warranty deed is what most people use. Okay, that's part of the quiet title action that you have to put on there. Adverse claim by defendant. That means the complaint must describe the defendant's claimed interest, whether it's a mortgage lien, assignment, judgment lien, or foreclosure deed that clouds or challenges the plaintiff's title. Invalidity of defendant's claim. The plaintiff must allege why the defendant's claim is invalid, unenforceable, or otherwise defective. Okay, so examples are void or fraudulent assignment, expired statute of limitations, satisfied mortgage, forgery, or lack of standing. Relief sought. A prayer that the court declare the plaintiff's adverse claim invalid and enter judgment quieting title in plaintiff's name. Often also seeks an order directing the county recorder to remove or cancel the cloud. Typical pleading language. This is generalized, guys. Plaintiff is the owner in fee simple of the property described as, and then you got your legal description there. Defendant asserts an adverse claim of interest in the property by virtue assignment of deed of trust, recorded on X date. Said claim is invalid because, and then you have to read go over the reasons why it's invalid. Plaintiff requests that defendant be required to set forth the nature of their claim and that such claim be declared invalid and that the plaintiff's title be forever quieted. And then there's some case law samples to look into. Mitchell versus Armstrong Capital Court. Unresolved title disputes can deprive a court of jurisdiction over foreclosure possession claims. That means that a JP court cannot rule on title disputes. So if you're in eviction court, the JP court cannot go over that stuff. You have to be in a regular court, like the state court or federal court, but not JP court. And then there's Summon Office Park versus U.S. Steel Corp. Standing must exist at inception. Title defects cannot be cured later. That's huge, guys. Everybody needs to really study that case. And Weiberg versus GTE Southwest Inc. Actions must be prosecuted in the name of the real party in interest, not the servicer. They don't have any claim to it. They just service the loan. These are things that we need to point out. Now, I also made a section here, guys, called Common Mistakes Pro Se Litigants Make in Quiet Title Actions. Failing to establish their own title clearly. Quiet title isn't about attacking the other side first. It's about showing your valid ownership. Mistake. Relying only on possession or saying, I live here, without attaching a deed, will, or other recorded instrument. Tip. Always plead and attach valid ownership document, warranty deed, or quitclaim, or a foreclosure deed. That's one of the most common mistakes people make, guys. Not identifying the adverse claim. Courts require you to specify what claim clouds the title. Mistake. Vague allegations like the bank has no rights without naming the recorded deed of trust, assignment, or lien. Tip. Reference the instrument, book page, or instrument number and date of recording. It has to be very specific, guys. It can't be very general. arguing show me the note as the main theory. Many pro se parties hinge their case on possession of the note, which courts often reject unless tied to concrete defect. Tip: focus on real legal defects. Void assignments, expired foreclosure statute, fraudulent recording, not just note custody. That's important. Mixing quiet title with damages claims. Quiet title is equitable to clear title, not about money damages. Mistake: asking the court to award damages under a quiet title heading. Tip: to keep quiet title count clean, bring damages under separate claims like FDCPA, RESPA, or fraud. That's when you bring your money into it, but not on quiet title. Not addressing limitations or statutory requirements. Some states, like Texas, have a 4-year statute for enforcing deeds of trust. And there's the law right there, 16035. Mistake: ignoring statutory timelines and conditions precedent. Tip: research your jurisdiction, statute of limitations, and pleading requirements. Improper parties. Quiet title requires naming all parties who claim an interest. Mistake is suing only the servicer, but not the trustee, assignee, or junior lien holders. So when you file a quiet title action, you have to name everyone that has a lien on your property, not just one. Tip: include every party of record with potential interest or risk dismissal. Not recording a lis penance. A lis penance gives notice that the property is under litigation. Mistake is filing suit but not recording a lis penance, leaving property vulnerable to transfer or foreclosure. Tip: always file and record a lis penance with your county clerk at the same time as your complaint. Okay, so when you file your complaint in federal or state court, you go down to your county recorder of deeds to file your lis penance. And there should be a blank on the lis penance to put your docket number on there. Pleading defects. Mistake: complaints that are narrative, disorganized, or fail to separate facts from legal conclusions. Tip: follow Rule 8 and Rule 10. Numbered paragraphs, clear factual allegations, and then your legal claims. I know I've gone over the way complaints should be properly formatted with you guys, so that's really important that your pleading doesn't have any defects in it. And the last section we go over here, guys, is what is chain of title? The chain of title is the recorded history of ownership and interest in a property. Think of it as a paper trail at the county recorder's office. Deed of trust, assignments, releases, foreclosure deeds. For title to be clear, the chain must be continuous and unbroken from the original grantor to the current claimant. What is a break in the chain of title? A break occurs when there is missing, inconsistent, or invalid link that is in recorded history. That means that the party claiming rights today cannot show a continuous record connecting back to the original borrower or lender. Common causes of breaks. An unrecorded assignment. This is the biggest thing here, right? I've seen this over and over again. Example is a servicer claims it got the loan in 2020, but the assignment isn't recorded until 2025, like in my friend Rachel's case. Void or defective assignment. Example, assignment executed by a company that was dissolved years earlier, like Sand Canyon or New Century issues. Okay, a dead lender cannot do an assignment. Conflicting claims. Example, 2 different entities both record assignments of the same deed of trust. And I've seen this happen too. Gaps in ownership. Example, the chain jumps from lender A to lender C, but no assignment from A to B is ever recorded. We see this a lot too. Misidentified parties. Example, complaint or assignment refers to Nation Star as the owner when the record still shows Gateway or another entity. See this a lot too, guys, where they name the wrong party as it's on the assignment. Why breaks matter in quiet title foreclosure defense. Standing. If the chain is broken, the foreclosing party can't prove it owns the loan or deed of trust. Void versus voidable. If an assignment is void, meaning it's forged, executed by a dissolved company outside authority, the borrower can challenge it directly. A cloud on the title is a break. A break creates uncertainty about who owns what and exactly what quiet title is meant to resolve. Jurisdiction. Some courts hold that unresolved title disputes deprive foreclosure courts of jurisdiction over possession. Now, as far as Rachel's case go, this is what I wanted to use as an example. In her case, the loan originated April of 2021 with Gateway. A loan modification was signed February 2023, supposedly with Lakeview. But Lakeview's assignment wasn't recorded until March of 2025. So they didn't even have authority to do that loan modification because they never had it. That creates a 2-year gap where Lakeview claimed rights without being in the recorded chain. Result, any foreclosure action by Lakeview is vulnerable because it cannot show a continuous recorded interest. So that's a good example to use, guys. I hope this information has been informative to you guys. And if you like my videos, please do the like thing and subscribe. And thank you for your likes and for subscribing to my channel. And if you have any questions or comments, you can leave them below. If you want to send me an email, my email address is the number 4, foreclosurehelp777@gmail.com. If you need help with your situation or have questions, I'll try to answer your questions as best I can. Okay, everybody, have a blessed day.